Effective repeal of penal law to liability of offender. Total or absolute, or partial or relative repeal. As to the effective repeal of penal law to the liability of offender, qualify your answer by saying whether the repeal is absolute or total or whether the repeal is partial or relative only. A repeal is absolute or total when the crime punished under the repealed law has been decriminalized by the repeal. Because of the repeal, the act or omission which used to be a crime is no longer a crime. A repeal is partial or relative when the crime punished under the repealed law continues to be a crime in spite of the repeal. This means that the repeal merely modified the conditions affecting the crime under the repealed law. The modification may be prejudicial or beneficial to the offender. Hence, the following rule. Consequences if repeal of penal law is total or absolute. 1. If a case is pending in court involving the violation of the repealed law, the same shall be dismissed, even though the accused may be a habitual delinquent. 2. If a case is already decided and the accused is already serving sentence by final judgment, if the convict is not a habitual delinquent, then he will be entitled to a release unless there is a reservation clause in the penal law that it will not apply to those serving sentence at the time of the repeal. But if there is no reservation, those who are not habitual delinquents, even if they are already serving their sentence, will receive the benefit of the repealing law. They are entitled to release. If they are not discharged from confinement, a petition for habeas corpus should be filed to test the legality of their continued confinement in jail. If the convict, on the other hand, is a habitual delinquent, he will continue serving the sentence in spite of the fact that the law under which he was convicted has already been absolutely repealed. This is so because penal laws should be given retroactive application to favor only those who are not habitual delinquents. Consequences if repeal of penal law is partial or relative. 1. If a case is pending in court involving the violation of the repealed law, and the repealing law is more favorable to the accused, it shall be the one applied to him. So whether he is a habitual delinquent or not. If the case is still pending in court, the repealing law will be the one to apply unless there is a saving clause in the repealing law that it shall not apply to pending causes of action. 2. If a case is already decided and the accused is already serving sentence by final judgment, even if the repealing law is partial or relative, the crime still remains to be a crime. Those who are not habitual delinquents will benefit on the effect of that repeal, so that if the repeal is more lenient to them, it will be the repealing law that will henceforth apply to them. Consequences if repeal of penal law is express or implied. 1. If a penal law is impliedly repealed, the subsequent repeal of the repealing law will revive the original law. So the act or omission which was punished as a crime under the original law will be revived, and the same shall again be crimes, although during the implied repeal, they may not be punishable. 2. If the repeal is express, the repeal of the repealing law will not revive the first law. So the act or omission will no longer be penalized. These effects of repeal do not apply to self-repealing laws, or those which have automatic termination.